Welcome. Please come. Please come.
Assalamualaikum.
Assalamualaikum. Please be seated. So, hello and good afternoon. My name is Mr. Ahmad, and I will be your
Mr. Wi-Fi.
Okay, so nice to meet you. I would like to explain some general rule in our mediation today. So, both parties must act in good faith, respect each other, and avoid interrupting or using profanity. And then, for this session, what we will be going through is both parties will give an opening statement. Then we will have a joint discussion where both parties freely to discuss. And then we will proceed with private caucus if any one of you would like to request to read. And then after private caucus, we will have a joint negotiation to resolve the issue. And lastly, we will end with agreement for our closure. So I will expect this mediation to finish in 30 minutes. And I would like to confirm first if both of you have signed a mediation agreement and have the authority to make a decision in this mediation session. In this mediation, after you've both spoken, we will move into more open conversation where we can explore what is going on in more detail and talk about a possible solution. So as we talk, I'd like you, both of you, to be thinking about what kind of resolution you'll be okay with. And you are welcome to ask for one too if there is something you'd rather share privately. Whatever we discuss in caucus, stay private, and unless you give me permission to share something in our mediation. So confidentiality is really important in our mediation. So if you share something with me privately and ask me to keep it confidential, I will respect that. So are you both okay with the confidentiality terms? Okay, so you notice me taking a few notes. Those are just for my reference. Feel free to take notes too at the end of the session. I will share my notes and you are welcome to share with me also. So thanks again for showing up. Your willingness to be here says a lot, and I hope we can work together to find a way forward. So before we jump in, do either of you want to suggest any ground rules for today?
No.
Okay, so the only ones I ask are to speak one at a time, avoid profanity, and give this suggestion fair consideration. Also, if any of you need to leave earlier than we expected, please inform me so that we can organize your time. So, any last question? Alright, so let's begin by hearing from both parties. Could one of you start by explaining what brought both of you here today?
Okay, you can start first, Mr. Zul.
Yes, please.
So I am representing Equate United Construction Company as the main contractor appointed by the Pimpinan Malaysia Berhad for the residential project Pro. So our company completed piling and construction work in 2008 and 2010 according to the specification in the PAN 1998 standard contract under the supervision of the developers of the contractor itself. We also received a certificate of practical completion confirming that the works were accepted as completed in accordance with the contract and was again under the supervision of the developers consultant. So in 2016, we submitted a claim for outstanding sum, and part of it was resolved through education. So now, the developer alleges that they caused structural damage due to the improper piling. But we believe that the actual cause is natural ground settlement and it was something beyond our control. The land itself was a former mining site. Also, we believe any claim should have been made by 2014, but it's only arose in 2017. Let's say that we are here today in good faith, open to a professional discussion, while we maintain our position that we have no liability. We are willing to explore any possible commercial resolution.
Okay, so just to confirm, are you saying that your company completed the works according to the agreed specifications? The project was certified complete, and you believe the current claims are not only outside your control but also time barred under the law. Is that correct?
Yes, that's correct.
Okay, Mr. Azwan, thank you. Now, Mr. Wi-Fi, could you please share your side?
Okay, thank you for letting me explain from our side. I am Wi-Fi, the CEO of Luna Amenities Member, right? Basically, our company has IAET integrated to the pilot work for our housing project. So after some houses were finished and handed over, we noticed serious cracks in the building. In February 2011, yeah, this was very worrying, and so we hired the independent engineers to check what was wrong. The engineers found that the piling work wasn't deep enough, which caused the damage. Even worse, the EK integrated tried to hide this by changing the records to make it seem like the piling was done correctly. So we only found the real reason for the crash in September 2011. Since then, we have spent more than 10 to 9 million to repair the damage. So we believe it is only fair that EK integrated pays a debt for this course. We also believe we may have the right to claim more because of the false records. We understand that the legal action has a time limit, but we think that the time should come from the when we discovered the problem, not when the piling was done. So we hope we can settle this matter fairly through this mediation and avoid going to the court.
Yes, if I may add, I would sincerely hope that we can resolve this matter through mediation. Since taking this to court will be undesirable for both parties, however, I will hesitate to file a suit on behalf of Mr. Wi-Fi if he agrees.
So, thanks to both of you for sharing. So, we may go to the next stage where is set today's agenda. The step is important to have a structure the discussion and ensure everyone has a chance to raise and explore all the key concerns that matter to both of you. So let me be clear that I am not here to make decisions or to suggest outcomes, but to have facilitate a structured and constructive conversation between both sides. So based on what I've heard, it seems like there are a few important issues to discuss. But I'd like to hear from both of you first what you would like to include into this agenda and in what order you prefer to discuss them. So we would like to be first.
Alright, I will speak on behalf of Mr. Wi-Fi. We would like to raise issues, which is firstly, the responsibility for the structural defect discovered in the experiment and whether those were due to worldwide work. And second, the question of classified factor and whether there was any misinterpretation by UK integrated. Third, the cost incurred by our company for repairs, which is 10.9 million, which we are seeking to be reimbursed by UK integrated. And lastly, we are open to discussing a commercial arrangement, but we must calculate the seriousness of the defect that we suffered and the financial loss.
Thank you, Mr. Wi-Fi. I've noted those down. Mr. Azwan, what about your side? Do you agree with this issue? Would you like to add a change or anything, or to suggest a different order?
So from our side, we also like to include our position that all works were completed according to the contract and properly certified by the consultants. And we also would like to add the completion period. We believe that anything should be brought before 2014, which now it has passed. So we are fine and open to starting this action.
So thank you both of you. So let me just summarize to ensure we are all on the same page. So there are 4 proposed agendas and the order of discussion for today will be first, liability for structural defects, second, allegation of falsified pioneer records, and third, the 10.9 million ringgit reimbursement, and lastly, the limitation period. So both of you agree? So I would like to call my assistant, Ms. Atul, to jot down our agenda today. So let's go through this issue one at a time. So can we begin with the first agenda, okay? So let's begin with the question of liability on whether EK integrated should be held responsible for the structural damage. Who wants to share their concerns on this first, like how we see our situation today?
May I?
Yes, please.
Okay, thank you. We noticed major cracks in 2011 after the homes were handed over. Concerned, we engaged independent engineers. The investigation revealed that the piling works were not done deep enough, which compromised the structural integrity of the buildings. So, we believe this was due to the negligence of failure to meet the specification under the PAM contract.
Thank you, Mr. Wi-Fi. So, Mr. Azwan, how would your side to share about this matter?
Okay, so to respond, indicating that all piling and reconstruction work was completed according to the specification and under the supervision of the consultant appointed by the developer. It's also important to highlight that the site was previously a mining area. Soil settlement and geological conditions are beyond our control, and this could eventually cause cracks over time.
Alright, so Mr. Wi-Fi believes the defects were caused by faulty piling works, while Mr. Azwan attributes it to natural settlement on the existing land. So, what are some possible ways both of you could take to resolve our issue today?
We like to consider a joint technical review by an independent party to validate the cause of the cracks again, to provide a fresh and objective view. Can we, Mr. Azwan?
Yes, that's so. We are open to independent review as long as the expert is mutually agreed upon. Since we also want clarity on the soil condition and whether it contributed to the damage.
Okay, I believe we should both find an expert and work together on this, since we are both need to review it together and see it ourselves.
Yes, I agree.
That's great. I believe the acceptance starts to play forward. Then I prepare the relevant document and estimate some independent parties to join for our joint review on the proposal.
Okay, so thank you for both of you. So one option may be commissioning a natural expert to assess whether the cause was structural or environmental. So are there any other approaches that you want to raise? Alright then, so can we all agree on this possible solution for the first agenda? Okay, so let's now turn to the issue of the falsification of the piling records. So, Mr. Wi-Fi, you've mentioned that you are concerned about the authenticity of the documentation, right? So, can you please explain why you feel like that?
Yes. Based on engineer's finding, the actual depth of the piles was not consistent with the record provided by Liquid Integrated. We have no choice but to suspect that the record was not falsified to make it appear that the specifications were made when they were not.
Alright, thank you. Mr. Azwan, how would you like to respond to that?
Mr. Wi-Fi. We strongly deny any falsification. All documentation was prepared in accordance with the standard practice and reviewed by the qualified consultants. If there had been any discrepancies, they should have been flagged at the time. There's no credible evidence that we altered any records.
So, what would a fair resolution look like to you? And what are your thoughts on this? And any of you can give your own idea so we can discuss together.
We want the records to be reviewed by an independent forensic auditor. If they are found to be altered, we may escalate the issue further.
We reject any claim that our documents were falsified. We see this as an accusation of fraud, and such review harms our reputation.
Why? Are you scared?
No, I'm not.
Okay then, please tell me what the reason was. What's so difficult?
Calm down, everyone. Let's take a deep breath. Please respect each other so that we can resolve so we can find a solution to our agreement soon. So let's together take a deep breath before we proceed in our mediation today. So, Mr. Azwan, what resolution would you like to offer to Mr. Wi-Fi? Was there a reason why the records appear to be different from the engineer's finding?
As I said earlier, the documents were prepared in accordance with the standard practice ADR. We also had been supervised by the building consultant itself. What more can we do to show that we do not make up the records?
See,
So what?
you're going to hit me?
You ask it, wait.
Get off my back.
Stop it, guys. I believe that I clearly said that both of parties must respect each other. No harm needed if you both act respectfully to each other. And let's not go down to that path. And I believe we all agree to keep this respectful. So there is no harm listening to each other calmly. That's how we will find a solution.
I want to take a break, please.
Alright, what about you, Mr. Azwan? Okay then, so I think that our issue here will be as unresolved, and we will continue after our break. So I think we will end. We will take a break from now. Welcome again to both parties. So if both of you ready, can we discuss our next agendas? Okay. So So next, let's discuss the 10.9 million ringgit that Mr. Wi-Fi has spent on repairs. Anyone would like to speak first?
Sebab saya ada explain that.
If you don't mind, I will explain on behalf of Mr. Wi-Fi. So, after confirming that the highway was inadequate, we had to carry out extensive structural repairs to ensure the safety and integrity of the road, and this includes underpinning and other remedial works, and the total cost amounted to 10.9 million, and we believe the company should bear that cost.
Alright, so if I understand correctly, you are saying that you will not be responsible for the cost. So, Mr. Azwan, what is your response?
We do not admit liability for the effects of the cost. We will not notify of any defect claims until the rules of the completion. We were not consulted before the repair work were undertaken, and no opportunity was given to us to inspect or to remedy the issue ourselves.
Understood. Thank you, Mr. Azman and Mr. Wi-Fi. This really helped paint a clearer picture to our mediation. So, just to make sure we are all on the same page, what I'm hearing from both sides is that we have a disagreement here regarding both liability and the cost of carrying out repairs. Is that accurate so far?
Yes.
Okay, so, what is your position on this matter, Mr. Azman?
For me, 10.9 million ringgit is much. They also did not notify us that they had detected effects. Why Mr. Wi-Fi did not tell us earlier and consulted with us before repairing all the works?
So, you expect us who did not have much knowledge about this matter to tell all the information that we just know from the engineers we hired? It's your job to do those things, not mine.
Okay. I only pay only 2 minutes because it's not our job scope to do such things.
Ahmad, I believe we should work on with the next agenda for now, since this issue is quite complex and may take some time to resolve.
Alright, I agree with Ms. Aina. So let's now address the issue of the time limitation, which is our last agenda today, shall we? So, Mr. Azman, would you like to begin?
Yes. So our works were completed between 2008 and 2010, and the certificate of practical completion was issued under the Limitation Act. Any claim should have been brought within 6 years, so by 2016 at latest. Since the claim only surfaced in 2017, we believe that the claim is timber, right?
Alright, Mr. Azman. So, Mr. Wi-Fi, would you like to respond?
Yes, Mr. Ahmad, I would like to respond on behalf of Mr. Wi-Fi. So, we argue that the elimination period should begin when we discover the actual cost of the repair, which was in September 2011, after we received the engineer's full report. Based on principle of date of knowledge, we believe the legal window was still open when we took action.
Alright, so I believe Mr. Azwan relies on the contract completion date, while Mr. Wi-Fi relies on the discovery date. Is that correct? So now, Mr. Wi-Fi, I'd like to hear from your view as Rimbunan Melati CEO. Why did you only take action in 2017 and not 2011, which is the year you know about the cracks, the defects? Could you help us to understand it better?
Who would like to know what?
It is true that early 2011, I guess, we saw cracks in some houses. But at that time, we didn't know exactly why they were happening. Cracks can occur for many reasons. So, to be responsible, we hired independent engineers to investigate. It wasn't until September 2011 that we received a full technical report confirming that the cracks were caused by shallow piling, wood that did not meet the required depth. What made the situation more serious was that we can discover that EK integrated falsified piling reports, which made it look like everything was done properly. We were shocked by that. Without the investigation, we would not have known about this wrongdoing. So, while we knew something was wrong in early 2011, we only knew who was at fault and why much later. And that is when the clock should start for the legal action. We took time to understand the full extent of the issue before taking a step, including exploring options like mediation.
I see.
However, I'm very sure that Mr. Wi-Fi is too late to bring this issue to justice. He supposedly took legal action once he discovers the cracks.
Mr. Azwan, please refrain from saying such things. We are here to discuss that matter peacefully.
I'm sorry, I'm not that type of person who acts without any investigation, and I will not accuse someone without any proof because I do care about Your reputation, Mr. Ahmed. I want to talk with you privately, please.
Is it okay with you, Mr. Arman? Thank you, Mr. Wi-Fi, for meeting me in this private session. As principal as well, everything you say here is completely confidential and will not be shared with the other side unless you give me permission. So my aim here is to understand your deeper concerns and interests and help you explore possible direction forward. So let's begin with the first issue. Your concern that the filing records were falsified. There is a strong allegation. Can you tell me what led you to that conclusion?
Actually, it wasn't just a feeling. After those serious structural cracks appeared, we hired independent engineers. These inspected the affected units and concluded that the piles were driving deep enough. They didn't match the official filing records. The discrepancy is what raised red flags. Like the records were made to show full compliance, when in fact the work itself wasn't done properly.
Alright, I hear that. It is understandable why that would be deeply concerning. May I ask, do you think there could be a technical explanation? For example, ground settlement or mining soil condition affect the result without intentional wrongdoing?
I acknowledge that ground issues are complex, but the records say one thing, and the soil testing and damage say another. If this was just a soil movement, why didn't it affect all units equally? And why didn't the consultants pick it up during construction?
Would your company consider engaging a neutral technical expert, not to point fingers, but purely to determine whether there is a natural explanation, or to clarify how much it was due to soil versus construction? Could that help move the discussion forward?
If it's truly neutral and done in a good faith, yes. But I would want the expert to be jointly appointed and completely independent. I don't want a whitewash. We have spent over 10 million fixing this. We just want to know about the truth and recover our loss.
So, if let's say that Mr. Azwan tells you the truth, what do you want exactly?
I want to know the truth, and I want reimbursement, and I want all my 10 million back.
So, if they don't agree with that, what is your alternative?
If they tell the truth but refuse to pay reimbursement, I can negotiate price. I just wanted the truth. I don't want anything else. I don't want to feel very bad about this.
Okay, so you agree to nego the price, but you just need to know the truth on whether they falsified the record or not.
Yeah.
So, is that correct?
Yeah, that's right.
Okay. So, let me jot it down first. Okay, so now let's turn to the limitation period issue.
Okay.
You argue the clock should start in 2011 when you discovered the cause, not back in 2008. Could you expand on why this is so important from your side?
Of course, when the units were first complete, everything looked fine. Wires moving, we had no reason to suspect anything. The serious stress only appeared years later. If it was only after we got our independent engineers to investigate that we understood the root cause. Before that, how could we take a legal action? We can speculate anything, can we?
Yeah. Okay, that is very clear to me. However, what if the contractor insists that the 6-year window has passed and continue to resist any formal claim? Will you be open to a commercial resolution, one that doesn't involve them admitting fault, but allows you to recover part of your repair costs?
Possibly, I'm not here to punish anyone, but I can't let our company suffer for something we didn't cause. We need something meaningful, whether the compensation or a contribution to our losses. Otherwise, it will feel like we are being left to clean up someone else's mess.
Alright, I appreciate your honesty. If I take this into account and we explore the option with the other party, anything else you want to know?
Yes, I wish you would stop hiding behind technicalities. We're not out to disturb them. We just want fairness. We were partners in this project. We both have reputation to protect. I still believe this can be resolved if there is sincerity of both sides.
Alright, I think that's all. Thank you for honesty. Here is all we want to discuss. I would like to have another topic with this person. Thank you for agreeing to this private session, Mr. Alban. Just to remind, everything we discuss here is strictly confidential and will not be shared with the other party unless we give the information. So this session is for you to speak openly and for me to better understand your interests, concerns, and what will be acceptable for you to move forward. So let's begin with the allegation that your company falsified filing records. How will you personally respond to that accusation?
All animal authorities are under the jurisdiction of the Bankers Police. If anything has been attacking out of line, it will have been caught at line. The suggestion that any falsified report is not as wrong is anything.
So I understand that frustration. From your perspective, do you think discrepancies in the report could be due to misunderstanding or the communication issues rather than wrongdoing?
I would like that the report of will not be correct, but that's not a falsification. We didn't find anything. I don't think it was like that. If there were discrepancies, the price of food should not that right.
Understood. If both parties agree to verify the filing and verify the issue, will your company be open to that as part of resolving this matter?
Yes, but only if the expert is clinical and is not investigated to have a
It's still just to propose you will need to have it checked by a neutral party. Is that correct?
Yes, as far as the words in your name.
Absolutely. So, ensuring neutrality and protecting reputation of interest would be essential for our relationship. So now, on the reputation issue, you are arguing the claim is time back because the work was completed in 2008. What is the important?
So, overall, let's look at set 2 years from the day. We can't without a true honesty It's about certainty. We can't operate under any strategy. And frankly, they set on their rights. If the patient is concerned, then it will draw for support.
So, there is a very strong point. What happens if the developer argues they only discovered the issue later? Would you consider settlement without anything for?
I'm not doing it without anxiety. It's very complicated, and I can walk away without doing it inside. And the mountains are example, and not really works exploring.
Understood. So, my final question is if there is anything you wish the other side understood better about your position or your frustration, what would it be?
So, we need to realize you will not notice. This wasn't a fly-by-night operation. You need to take our contract and decide on. I also think we have been unfair in how we compare this. We're open to commercial discussion, but not your unit is big.
So, if there is anything else to say, I think we will give to our brother talks. And we want to. Thank you both persons for coming back together. Now, let's continue with our next process, which is joint negotiation. So, this is an opportunity to directly express your position and interest. So, let's begin with the issue surrounding the filing records. So, rather than discuss what we have been said before, I would like to ask a question to both of you. Would either of you be open to the idea of technical evaluation by a neutral party, professional manner, and without assigning any legal blame?
It depends on how neutral and independent the evaluator is. If it is someone both of us agree on, and the review is strictly technical, not legal or emotional, I think that will help to clear the air.
Thank you, Mr. Waifan. So, Mr. Azwan, how would you feel about this?
So, I wouldn't object to a technical review, provided it's not treated as a trial or an accusation. If we're talking about a balance, expert opinion on facts, that's something I can consider.
I understand. So, if you move in that direction, the next step would be to jointly select an expert and agree on what they are about to evaluate. So, we both be willing to work on that together. Alright, so thank you. I will have facilitated a structured discussion on how the expert is chosen and the scope of their work. So now let's move on to the second matter that is being mentioned, the question of time. So more specifically, when each side believes that the issue becomes known and whether action was taken in a timely way. So given the complexity of construction and defect discovery, how might both parties view a commercial solution, one that avoids determining legal liability but still address the consequences in a way that's meaningful for each side. So, can I ask Mr. Azwan?
Yes.
So, Mr. Azwan, what would a constructive resolution on this issue look like to you, especially if no admission of liability is involved?
Well, if it's about moving forward commercially and not accepting blame, I could consider some kind of structured discussion, but it has to be clear that we are not accepting responsibility for something that long past.
Alright, thank you, Mr. Azwan. So, Mr. Wi-Fi, from your point of view, if formal legal timelines become a sticking point, would there be a value in a solution that focuses more on outcome rather than on legal position?
Possibly, yes. We are looking for something that reflects the cost we have borne. If the result help us recover part of what we have spent and being handled fairly, we could get an open mind.
I see. So, both of you seem open to the possibility of a commercial arrangement, depending on the form it takes and the findings of a technical review. So, with that in mind, allow me to ask another question. If a neutral technical assessment identifies certain causes contributing to the issue, not necessarily placing blame, would either of you would be willing to negotiate a financial resolution that reflects those findings? So, Mr. Azwan, would that type of approach allow you to meet your company's goals?
So, if it's handled carefully, yes. But again, we need clarity on how it's being done.
Understood. And you, Mr. Wi-Fi?
Yes, especially if we can understand what really happened and the financial aspect is treated fairly.
Alright, so before we proceed to draft the summary of our discussion, I would like to return to both of you one last time and ask, are there any final thoughts or clarification that you'd like to make, or anything you believe should be included as part of this partial resolution? So let's start with you, Mr. Wi-Fi.
If I may speak for Mr. Wi-Fi, our main aim is to get clarity and fairness. We are not trying to harm anyone's reputation, and we have invested a lot into rectifying the defect, and it has impacted our financial. We hope the expert assessment will help both sides fix the facts honestly, and also we want to be sure the process is not delayed or dragged out, and we want to move it quickly.
Okay, so thank you for that. So time is of the essence and transparency is key. We include a proposed time frame when we draft the agreement. So Mr. Azwan, how about you?
So I appreciate what Mrs. Alma has said. From our side, we just want to be treated fairly and not to be blamed for something that we didn't do. We're not open to solutions, but we cannot accept assumption or one-sided narrative. I hope the neutral expert will look at things objectively, and I feel that it shouldn't be a never-ending process. So we need a clear path forward.
Alright. So thank you, Mr. Wi-Fi and Mr. Azwan. I appreciate the professionalism and effort you've both shown today. So from what I gathered, we've made a good process on a few fronts. Let me try to summarize where we are, and please correct me if I have missed anything. So first, both parties have expressed willingness to appoint a neutral technical expert, jointly selected and mutually agreed upon, to assess the filing issue. And this expert's role would not be to assign fault, but to provide an independent technical evaluation, particularly in determining whether the cracks and defects stem from ground condition or construction practices. So, Mr. Azwan, would you be comfortable to confirm that your company agrees to this approach?
Yes, as long as the expert is neutral and the process is technical, not a legal position.
Understood. Mr. Wi-Fi, is this also acceptable to you?
Yes, provided we both agree on the expert and the scope is clear, it's about finding out the truth, not labeling.
Excellent. I will assist both parties in preparing a shortlist of expert candidates and drafting a proposed scope of work for your mutual consideration. So, second, both parties have expressed openness to a commercial settlement regarding the 10.9 million ringgit repair cost. So, this negotiation will take place only after the technical expert's report is available and will not require any admission of liability. So, Mr. Wi-Fi, can I confirm that you are prepared to discuss a flexible reimbursement arrangement based on what the expert determines?
Yes, I'm willing to negotiate. I've said from the beginning, if they are honest and we get clarity, I'm flexible on the number. It's not about commission.
Thank you. So, Mr. Azwan, how does your company view this possibility?
We are prepared to consider numbers if the fact justified, but it must be fair and not to look like we are being forced into something that we didn't do. We'll look at the numbers seriously once the technical reports are ready.
Absolutely. So, we can arrange follow-up meetings for that negotiation once the experts' findings are in. So now let's move on to the more sensitive matter of the falsification of pioneer records. And you've both decided to let the technical report stand as the final factual reference. So this approach will help avoid reputational damage, maintain integrity, and allow you to move forward constructively. So, Mr. Wi-Fi, do you confirm this?
Yes, we will be satisfied with that, and we won't push the issue further as long as we get a proper review. We want to move forward and not escalate.
Alright, thank you. Mr. Azwan?
Yes, we released to put that behind us. We trust the technical finding will help everyone understand what we have.
Alright. It is a very positive step from both sides. It is a difficult issue, and you have handled it maturely. Next, on the limitation period, we acknowledge that your legal teams have differing views on whether the claim is time, but both parties have now agreed to set aside the legal agreement and proceed as if the claim is commercially valid, again without admitting liability. Mr. Azwan, are you comfortable with that?
Yes, we don't want to get watched down in the room because we are willing to resolve cases as a commercial matter.
And Mr. Wi-Fi?
Yes, I agree. It's more important to find a closure than to argue about legality.
Alright, excellent. So to summarize, both parties have reached all our agendas today. We reached first, a jointly appointed natural expert will evaluate the filing and structural issues. The second, the expert's finding will form the basis for commercial discussions on reimbursement of repair costs. And third, allegations of falsification will be set aside in favor of the expert's independent assessment. And lastly, the limitation period issue will not be pursued legally. So I will prepare a draft mediation agreement reflecting all these points. You will each have a chance to review it with your legal advisors before signing. Once again, thankful both parties. It is not easy to reach this level of cooperation, especially when the issues are complex and emotionally charged. But your willingness to engage constructively shows real leadership. So, shall we close here for today? Alright, thank you.